Ever wonder how retirement plans in a divorce case get divided without having to incur substantial taxes and penalties? I'm Jerry Maggio, Southern California divorce and family law attorney. In today's video, I'm going to explain what qualified domestic relations orders, or QDROs for short, are, and why they're usually necessary in divorce cases to avoid the parties incurring substantial penalties and taxes in the division of such plans. As I stated, most divorce cases that have retirement plans usually require a QDRO to be done. So what is a QDRO? A QDRO is a legal order that explains how the retirement plan is going to be divided, keeping in mind the date of marriage of the parties, the date of separation, what contributions were made during that time period, and how in turn the account or plan needs to be divided pursuant to the requirements of the retirement plan. So let me explain to you some key things to understand about what a QDRO does and what's necessary and involved. Number one, the purpose of a QDRO is to determine that a retirement plan is divided equally, fairly, and keeping in mind the duration of the marriage from date of marriage to date of separation, because anything that was put into that retirement account during that period of time of the marriage is generally considered community property under California law and will need to be divided pursuant to the requirements of the plan and under federal law. Number two, qualified status. In order for a plan to be divided by a QDRO, it must be qualified. And what that means is that it has to meet the requirements of the plan, your 401k plan, your deferred compensation plan, and so on. And it also needs to comply with the federal ERISA laws that dictate how retirement plans such as pensions, 401ks, and deferred compensation plans are divided. Number three, division of the actual retirement benefits. A QDRO will spell out exactly what each party will get out of the division of property of these retirement accounts in the divorce and what percentages of those accounts each party is going to receive. Number four, tax implications. This is one of the big benefits of dividing a retirement account by a QDRO. There's generally no tax implication by dividing a retirement account by using a QDRO. Essentially, for example, if you have a 401k or a deferred comp plan, what will happen is the QDRO will determine what the other spouse is entitled to, and that spouse will then get a rollover IRA to them in their name, automatically becoming their own retirement account. But by doing a transfer in that manner, there will be no tax implication involved by the transfer. There's no penalties and no tax problems involved with dividing a retirement plan in such manner. Number five, types of retirement accounts. As I've stated before, QDROs are particularly necessary and useful in the division of pensions, 401ks, and deferred compensation plans. They're not really necessary to divide an IRA, but they are, as I indicated, on those other plans. Number six, specific language. The QDRO has to have specific language that relates to exactly what the plan requires. Each plan, like a 401k, requires that certain language be put into the QDRO. And so therefore, the plan administrator for your 401k or deferred comp plan or pension has specific language that has to be in the QDRO pursuant to their own requirements before they can divide those retirement accounts. So a family law attorney can prepare a QDRO, but that has to then be approved by the plan in order for it to go to the next step and become a court order. Number seven, court approval. Once the QDRO has been approved by the retirement plan, all parties sign it, it's submitted to the court for filing. When it comes back from the court and has been filed, then it's sent back to the plan, and then from there the plan can proceed to divide the retirement benefits. Number eight, the plan administrator's role. As I think I've explained in this whole process, the plan administrator is a key person that is dealing with and determining if the plan that's been prepared in your divorce case is appropriate, is approved by the plan, and then therefore can be filed, and then from there the plan benefits can be divided up. And so it's really important to have an attorney that's doing that to make sure that's done properly. I'm Jerry Maggio, Southern California divorce and family law attorney. If you like this information on this video, please feel free to subscribe to our YouTube channel for more helpful information about divorce and family law issues. See you next time.